Let's get started at torts class. Thank you for attending. Contributory and comparative and collateral source rule. Not super difficult concepts, but I think it requires taking notes and thinking. It's because you can mess up on the difference between collateral source and things like contribution and things like that. If you had pure contributory negligence, it was so harsh that a lot of juries really didn't go by it. So I think the legislatures ended up just giving up and saying, well, they're not really going to follow strict contributory. Contributory negligence, at least in some states, was, like I say, very harsh. If the plaintiff even contributed to the plaintiff's own harm, then the plaintiff didn't get money, and juries didn't think that was fair. And you can see why. If most of the fault, most of the causation, and most of the fault was a breach of duty by the defendant, the plaintiff should get something. Yeah, there's the rule that people call the 50% rule. There's one that they where they think that the defendant has to have had more fault, which they kind of call the 51% rule, which is not technically 51%. It's just that there's more fault. You know, if it's equal, in theory, maybe neither should be compensated, but it depends on the state, right? Depends on state law. These things kind of contradict themselves, but they don't necessarily apply to the same case. Some cases have subrogation and some doesn't. Some don't. This seems unfair because if the person's already been compensated, why do they get more? But you'll have to just think about it on your own and decide what you think about it. But if it's the law, it's the law, whether you agree with it or not. But think about how you would vote if you were a legislator about that, and that'll help focus your brain on it, okay? That's how I do it. Think about it as if you were a legislator. How many think being a legislator in the state legislature is out of reach for you? Thinks you couldn't do it? It's a trick question. How many think that somebody whose experience with work is mostly being a daycare provider could not be a state legislator? What do you think of that? They wouldn't get to decide things like this. What do you think of that? And I'm trying to ask it kind of open-ended. In other words, what do you think about it? My former state legislator from my area, actually, she ended up being in a different district because they redistricted. But for a while, my legislator was a nice person who used to be a daycare provider, okay? So you don't need to have been, you don't need to have owned a bank, been the superintendent of schools, been a lawyer or something like that to be a state legislature. So it is a very realistic thing for any of you to become a state legislator. Tor. So think about these things from the top side that you would actually help make the decision, and then also think about it as you're practicing paralegal where somebody else has already made the choice and where you have to just write down the answer, because subrogation applies to some things, collateral source rule to others, and sometimes both. So health insurance or workers' compensation, the money is not reduced. Other types of things, the money is ultimately reduced because you have to give up money to an insurance company that's already paid. That's subrogation. If I get money for certain medical bills, then I have to, and I don't have to pay the medical bills because they've already been paid by medical insurance. The medical insurance will actually get it. Does that make sense to you? Okay. Yeah, it's in some ways that's easier than the collateral source rule, even though it subrogation is an odd word, odd legalistic word from the ancient world, you might say. Issue, rule, application, conclusion. So basically, what is the problem? And this is the general law on this kind of problem. And then, of course, apply to the problem. And then conclusion is basically which side wins in your view based on your application. Yeah, it was interesting because I was wearing my one of my Rasmussen jackets, and I went to a bar association meeting, and there's 2 Court of Appeals judges there, and they're near the top of the legal profession of my state, you know, and I suppose you think I'm an extremely famous lawyer, but I'm not. I'm just old. But I was there, and I went and asked them a question about paralegal studies because I said, well, would you recommend using IRAC? And they both did. And one of them actually leaned over, one of the nice ladies who happens to be one of the highest judges in our state, leaned over and kind of straightened out the collar on my jacket. I thought that was cute. You know, and of course they're all younger than me now, so they can get by doing something like that, I suppose. You know, you want to help the old man. Maybe if I hadn't had my shirt tucked in, they would have reminded me. I don't know, but I thought that was kind of cute. You know, and you find out that people that make these final decisions are personable. They will answer a question. You know, from an I guess I can, in that context, I'm kind of an ordinary person. You know, being a lawyer at all, being a teacher is certainly a high office, but in the order of the state government, they are far above me. And yeah, one of them straightened out my little collar. You know, I had a kick out of that. So you do the best you can on this written assignment. Is it all about being right? It's not all about one right answer. It's about the analysis method and of IRAC and coping with case law on negligence, okay? So when in doubt, show your actual thoughts you know, sometimes um, you may have trouble analyzing the law. Uh, it's not against the rules to use um, the head notes. Who has used a head note in Lexis? Yeah, head notes. Uh, it's it's uh, it's not cheating to use a head note. Um, the problem with using a head note is sometimes the head notes are purely procedural, and they seem strange because you see a head note that's purely procedural, or you see one that's so general that it could apply to thousands of cases. Those you say that can't be the answer in common sense. You would be right. If it looks like it's so general that it's ridiculous, uh, then it's just reminding you of a principle of law that's not very specific to the negligence case, okay? And it may have nothing to do with contributory or comparative negligence. Um, um, I'm not sure if I can find it without the site. Oh, for crying out loud. I guess I can. I think so here. You shouldn't be able to find it that easy by just case name, but I think I did. Okay, can you guys see leave the yellow cab? Okay. Yeah, and here's an example of head note 3. Not a bad thing to know, but it won't help you this time. Uh, so something that looks like it's not real specific to tort law in common sense, you would be correct. It's not very specific to what we're doing this week in tort law. This looks like tort law. This does. These kinds of things will help you, but some of the others are nice to know, but they won't help you on specifics. We're not really working on this, for instance. So I'm trying to help you just realize that the fact that a highly qualified research help, which Lexis is, did this and head noted something doesn't mean that it applies to what we're doing this week. It may be just very generalized and they're just extremely thorough, okay? Yep. And then you can look at Shepard's and so on, but you don't want to look at 754 decisions. You don't want to be that, you don't want to be super thorough, like $14 million is at stake this week. It's not. What you want to do is you want to get to the basics of comparative fault, contributory negligence, that kind of a thing. And of course, then you want to be able to, you won't necessarily have to use a lot of Shepards. You're really not having to do all of that. And so the other thing is it's not against the rules to look in the text to figure out things like this. And I'm going to ask, you don't have to answer this in the chat, but how many know that you can do a search in the text? I better look and remind myself, is there a textbook for this course? I think there is. Then we use a text. Yeah, we have torts and personal injury for the paralegal. Yeah, I've used this. I used this when I taught the course before. But it's not against the rules to do a search in the text. And you say, well, but it got me to the wrong chapter for some of the information. That's okay. There's nothing wrong with going up to torts and personal injury and doing comparative. You got comparative 50, 5149. What's wrong with that? Or contributory. And you say, but that's not the same thing as going to the that's not the same thing as going to the case, correct? But the case may not answer all of these questions clearly for you. I don't know if you guys can see what I'm doing. Can you see that I'm typing in the little question oval? I know students have gone through all the paralegal studies and have never looked at a text this way. I know that has happened. And I understand. I mean, I agree with the way you're doing it in many ways. That you like to be extremely thorough, and you write like. But I disagree with the idea that you have to always read page by page by page. Sometimes you need to skip around and skim. You may use the text as authority for collateral source rule and subrogation. But I want you to analyze it yourself. Think about it. So don't just use the text and call that your answer. Whenever you use something, try to show your own personal analysis. What's your thinking? But yeah, it's small, but could you yep, okay. Okay, I'm seeing the chat. But it's were you able to see what I was doing somewhat in terms of I was just typing in that little oval search box, then clicking on the little, okay. And you don't want to get too darn specific when you search inside of a text because it doesn't like to, it's not a research tool that way, but it'll get you to a general topic. You probably don't want to type a huge amount in there and then expect it to get you to something extremely specific. You want to use it for definitions. Use text for definitions, and then of course you realize if you want something very, very specific on a new case or something, yes, you will have to go to research, more of a research-based approach. But you want to find a definition. The text is better than what you find outside the text typically. And it's more understandable and it puts it in context better. I think you guys are doing pretty good with the railroad against Bill Larson. I'm not really having any problem with that. The only problem I have with is that not all classmates are posting twice or using a source, and try to talk them into it. Showing a source. The case itself works, but quote a portion of the case. Or a case, you know. Any case helps. or a rule or a statute. Okay. And then just asking a classmate a question, ask a question to remind a student to post again. I hate to see promising students sort of have difficulty just due to the fact that they don't wish to post twice, they don't wish to use the source. When they have the capability of doing that, I hate to see them lose opportunities, put it that way. It's not necessarily always about grades, but it is about grades too. And a promising classmate should not lose the opportunities. I'm not saying you lose points. You haven't gained them in the first place. How can you lose something you never gained? But I want to see everybody take the opportunity to gain grade points by posting twice. And it's not just simply create some kind of a hurdle to jump over. It's because interaction with other classmates sparks your learning, makes it more real, like having real coworkers who expect you to say something or type something. You say, what a boring place to work. Nobody really interacts with me at all. Well, then I hope when you arrive at the boring place of work, it becomes less boring because people start interacting. If you ask a question, maybe it's even just something that you send in a memo to the class, not to the class, of course, to the other people working there. That sparks thinking, well, you know, we could do this better. Yes, we should look at the fact that there's a new statute that is about to go into law in August. And I'm sure glad Angie, Bess, Mary Kay, the rest, I'm sure glad these other employees were there that found this and have been talking about it, because we'll have to change our procedure. The quiz is 30 true-false questions. So I'm going to pause. I don't have other stuff, but would you like to have some other stuff in Lexis or anything? I'm going to stop right here. If you have more questions, please ask them in the course messages, and I will answer when I can. I don't believe, let's see, I don't believe we have one this time, do we? Let me look. I thought it was not in the odd numbered weeks. Yep. Yeah, none. Maybe I didn't have that on the, well, we'll type that. There is no live class attendance quiz. Just a regular. Okay. Thanks very much, folks. Thanks for working with me.